I want to give viewers a little more context on what is a big development. Until today, think about it like this. Every single person who has spoken publicly about this Mueller probe, who's been involved, has at least publicly said they'll cooperate.
Are you going to talk to Mueller?
I'm looking forward to it, actually.
Very eager.
Okay.
To explain to the special counsel, whatever responses are required.
And we will continue to cooperate with Bob Mueller in his investigation. We'll continue to cooperate and comply.
I'm more than happy to be transparent about it, and I'm more than happy to cooperate with everyone.
And yet today, as we just saw, a different tack. I want to turn to attorney Maya Wiley, who's a former counsel of the mayor of New York City and a talented and knowledgeable legal analyst for us. And you were also at this table with Mr. Nunberg, who is still with us, the last time he was here, and he spoke about what was, again, for viewers following this, the FBI interview. That's not the grand jury box, that's an FBI interview. Now, what you just heard from him, your analysis.
Well, I'm really quite flabbergasted at the statement that Sam, you don't believe that there is anything that you would share that would implicate Roger Stone in a crime, and yet you would not actually come forward in a grand jury and then repeat the statements you've made already directly to federal prosecutors in front of a grand jury. It's rather astounding. The way I've seen the subpoena, it is a reasonable subpoena. It does not sound like a huge random fishing expedition.
Mr. Nunberg used the word broad. Is your view that it is very broad, or that it seems targeted?
It seems pretty targeted to people who are directly implicated in the investigation already by many things. If there are emails that do not exist, they can't be turned over, and it can't be burdensome to produce them.
Let me ask you this, Mr. Nunberg, who's taken time to be on the show before, which I appreciate. He said many things, some of them shocking, some of them may have been based on conjecture. He did say one thing that I mentioned earlier that struck me as very reasonable and something I've heard from a range of people caught up in this situation, which is, if I cooperated and I didn't do anything wrong, and I've been told I'm not the target, and I'm spending all this money, why is it getting more pressure on me? Why the heat? What did you think of his concern there that might be animating how he's feeling?
I think it's a very human response to being a witness in an investigation. It's stressful. It is time-consuming. There's no question that in the process of trying to get to the truth, which, remember, it is the grand jury that will decide whether or not to indict, so that the grand jury can hear the evidence that the prosecutors have heard in order to understand the facts and circumstances that are being brought to them. So to sort of suggest that talking to the prosecutors is sufficient in the context of an impaneled grand jury is sort of saying, let's have justice with both eyes not just closed, but gagged and completely unable to engage in a criminal investigation.
And this is where I'll disagree with you respectfully, is that I felt they were very biased against Roger when I was in there. I felt that they're going after Roger. I felt Paul Manafort and Rick Gates did illegal things, and they couldn't pay the taxes. I don't know why they didn't want to pay the taxes, and they worked for Russian oligarchs. Roger didn't work for Russian oligarchs. They asked me things. In other words, once again, as I just mentioned earlier, ma'am, is that they asked me things like, was this some grand plot by Roger and me to get fired? And then I would work for Ted Cruz, and then we would collude with the Russians. I mean, it's ridiculous.
So Sam said here last week on Wednesday that this was an extremely professional and highly skilled team. So the notion that they were asking questions, first of all, does not mean they were suggesting that that there was answers that would be true or false, right? Only that there were things that they were going to pursue. The fact that they asked them in and of themselves has nothing to do with what they will ultimately decide to take to the grand jury.
I believe they're biased against Roger.
But if we had a justice system that said that witnesses could decide the guilt or innocence of any particular individual and therefore not cooperate and make that legally permissible, essentially we would not have any system at all.
Can you speak to that structural point that Ms. Wiley raises? Because what she's saying is...
I think
wait. Okay. What she's saying, I just want to be clear. You get time.
I know.
I do. What she's saying is that you may have, put it in the best light possible, you may have a good faith, honest belief in your position and the innocence of your very dear friend, and I think anyone who's fair, who's watching, can relate to that. It sounds like you care a lot about someone, and you think they're in the right.
He's my mentor, and he's
you
like a
don't wanna
father
hurt
to me.
them. And I think if anyone's fair and honest and thinks about the person that in their life that's in that role, they could understand the feeling you have. And yet Maya Wiley is saying something that's broader than that, which is you have, as I mentioned earlier in the interview, you have an obligation or federal law to comply, because it's not your call or my call or Maya's call. It is the call of justice, which we have prosecutors charged and courts to adjudicate. What do you say to her point that it's not your call?
I say, one, you're right, and I'm making it my call. But here's what I also say. Why did they not indict Podesta, Podesta's brother?
Tony Podesta probably has, according to the reports, significant foreign lobbying exposure here.
Correct, and he worked for Manafort.
I can't prejudge it. I can't prejudge it, but he is a person who, because it's not over.
Because here's what I would say, and here's where we can agree to disagree. I always find that with these investigations, whether it was Scooter Libby, whether they didn't charge Hillary Clinton, that there's always a reason that the Democrats don't get tried and the Republicans do. Now, you're going to laugh at me.
I'm going to definitely laugh.
You are going to laugh at me. But you explained to me why she didn't get indicted. She hid her emails.
Well, but I'm going to use moderator's privilege and say,
yes, sir.
You're trying to change the topic.
No, I'm not changing the topic. What I'm saying is,
the questions here are, and the reason you're here,
that the statutes are so broad.
The reason you're here is you seem to be taking a position that is befuddling and really affecting a lot of people, and people are wondering, is it the right decision for you, and is it the right decision under law?
And here's why by the way, once again, Roger's my mentor. Roger's like a father to me. I don't care. They can take down Donald Trump. Take him down. If Donald Trump did something, take him down.
So you're saying you would protect Roger but not Trump?
I'm not going to go into a grand jury for them to set up a case against Roger, whatever case it is, which could be ridiculous.
If it's ridiculous, there's no reason for you not to go and help him by sharing what you know. The suggestion and what you're essentially projecting to me as an attorney is that you're actually protecting him because there's something to protect.
There's nothing to protect.
So you would do more service to your mentor by demonstrating that he has nothing to fear if, as you say, there's nothing in the emails. You, as far as you know, have never seen or heard any contact between him, WikiLeaks, Russians that connect to the campaign.
These statutes, they take these statutes, as you know, as a U.S. attorney, and they're so broad, they can find a way to just charge.
So you're worried, just to be clear, you're worried they could make a case against Roger Stone?
I'm worried that they're trying to make a case against Roger, that they're maneuvering.
And what would that case be built?
I have no idea. I have no idea, but it's ridiculous.
Would it relate to WikiLeaks?
I could tell you, once again.
Would it relate to WikiLeaks?
It could relate to WikiLeaks. And here's the other thing, what I would tell you once again, and I wanted to be, and I've been very honest here. I was fired, Roger quit. We were treated like crap by Donald Trump. Roger could have done whatever he wanted. And I had a fight with Roger about this. I was happy to see Trump lose during the summer.
Do you think the president saw your last interview on this show?
He did, and you know what? I don't care.
You know that he did?
No, I said, yeah.
Yeah. What do you want to say to him tonight?
I don't care.
You don't care?
I don't care what he thinks. You know, I don't care. Once again, I worked for him from 2011 to 2015. He had separate sets of rules for Roger and me. When he hired Corey Lewandowski, who he thought left the Kochs to go work for Trump, which he did, and Corey was fired, and that's a fact, and Corey can come on your show and dispute it. He decided that we were trash. And then, as I've told you, he treated Michael Cohen very badly.
Are you worried about Michael?
Yeah, like I'm worried about Michael because I don't, by the way, Michael did not do any, I don't know if
I'm going to bring in a former federal prosecutor who also has expertise on this, but let me ask you this question. Does your lawyer think what you're doing now tonight is a good idea?
I have no idea. I think he may have dropped me, frankly. I don't know. I definitely know my father doesn't like it, and my father was one of my co-counsels.
I think your family wants you home for Thanksgiving, and I hope you will testify.
Here's the thing, though. Isn't this ridiculous?
No, it's not ridiculous, Sam.
Is it November?
So not ridiculous.
November 1, 2015. I talked to Steve Bannon and Roger 15 times a day from November 1 to 2015.
Well, talking to them in emails are two different things. So they could subpoena your phone records as well. And
they're more than welcome to.
But my point is, if you had email exchanges with them during a period that is under investigation, with people who have clearly been implicated in some way, that doesn't mean they've committed a crime, but clearly have been implicated in transactions that relate to understanding whether or not there was a violation of federal law here, then it is a completely reasonable request to ask for those emails.
From November 1, 2015.
It was the period of the campaign in which there were, all you have to do is go back in the timeline.
By the way, to the present. To the president.
Yes,
Let me do this
common.
as promised. Hang with me. I want to bring in a former federal prosecutor, Barbara McQuaid. I guess I will begin with a point that Sam raised. Have you ever seen anything quite like this?
No, I haven't. Typically, people comply with grand jury subpoenas. You know, there are a few bases that a witness can use to object to a grand jury subpoena. One is if they have some sort of privilege, like a Fifth Amendment privilege against self-incrimination, attorney-client, spousal privilege, or the like, or if they believe that the request is unduly burdensome. And the remedy there is to file a motion to quash with the court and ask the court to narrow the scope. If that is granted, then a prosecutor might say, we'll ask you for fewer documents if this is unduly burdensome. But other than those circumstances, if a witness refuses, then I do think they face contempt of court and possible jail.
And contempt of court, as Mr. Nunberg and I were discussing earlier, can bring jail.
I'm not going to jail. Come on. All right. Do you think I'm going to jail?
Well, let me put it to the federal prosecutor, and you're still here, so you're part of the discussion. But, Barbara, if we take Mr. Nunberg's argument in the best possible light as a legal argument, it would be something that you just referred to, which is maybe this is an overbroad request and it should be narrowed. Now, typically, as I think we all know, and as viewers will know, because this does feel so unusual, typically that would be a private set of negotiations through lawyers and not played out in public. And from what we know about the Mueller probe, that is not the preference of the investigators. So your view of that aspect of this, Barbara, and what they may or may not or legally could do with a witness who is divulging so much?
Yeah, I mean, the first step would be for a lawyer to communicate with the prosecutor and ask if the scope of the subpoena could be narrowed. If that is refused, then to file a motion to quash. But short of that, I think that a judge could very well hold a witness in contempt. And I would think in a case like this, where a witness is so publicly defying the subpoena power of the special prosecutor, I would believe that a prosecutor would feel a very strong desire to file charges, to file a motion for contempt, because you have to think about the deterrent effect that that might have on other witnesses who are out there, not just in this case, but in every case going on across the country.
So, Barbara, another follow-up on that to you, and then, Mr. Nunberg, your response if you want. But, Barbara, what you're saying is under the law, we're not here to predict, but you're saying under the law, based on what's happening at Mr. Nunberg's own account, that there was one grand jury subpoena documentary deadline that he's passed now today, and the other one is testimonial, that is him going in, that he vows to defy. You're saying they would be in their legal rights to file a contempt proceeding at what point?
Well, I do. You know, again, I think lawyers typically try to work things out. If a witness says, I don't have enough time to go through the emails you've requested, you can ask for an extension of time for those things. So there can be an attempt to work things out. I would imagine there would be a request, is he really defying our subpoena? Because I've heard a lot of reasons. I've heard unreasonable. I've also heard I don't want to incriminate my mentor, Roger Stone, which would not be an appropriate exercise of the Fifth Amendment right, which is about self-incrimination, not against incriminating others. So I think they would want to clearly define what is the basis for your objection. Do you just need a little more time, or are you truly defying this subpoena? And if it's the latter, I do think a motion for contempt of court would be appropriate. And you asked about if you've ever seen anything like this. The one example that comes to mind is Susan McDougal, who refused to testify for the special counsel in the investigation of Bill Clinton. She was held in contempt and was jailed for 18 months for that contempt.
So, Sam, your reaction to hearing that laid out here by a federal prosecutor, and your reaction to, I think, the implication of what Ms. McQuaid just said, which was, and I'm going to put this, again, I try to be fair, but I try to be accurate.
Yes, you are being fair.
What I'm about to say sounds bad, but I'm going to say it to you. The implication of what she is analyzing there under the law is that the way you are speaking out, and you've spoken out several times today, this is not the first time you've spoken out today, the way you're speaking out, she said, is actually potentially hurting, undermining the type of case you might make for why you shouldn't have to testify, because you're putting forth the idea that you might not want to testify to protect someone else's conduct.
Well, I'm not protecting Roger's conduct. What I would say is they went after Paul Manafort, they went after Gates. Now, Paul Manafort and Gates, I've never spoken to. I met Paul once at a Yankee ALCS. They went after them from the very beginning for activities earlier than the campaign. If they're trying to build a case against Roger, I'm not going to be part of it. I'm not. Roger didn't do anything. Roger didn't do anything except get treated like crap by Donald Trump, the president.
You keep saying you don't think there'll be a consequence. What if the consequence for that is going to jail, Sam?
They're not going to send me to jail. You know what, Mr. Mueller, if he wants to send me to jail, he can send me to jail, and then I'll laugh about it, and I'll make a bigger spectacle than I am on your TV show right now.
Well, sir, I don't know what they're going to do. I don't know that, and I can't prejudge it.
I know you can't. Yeah.
But Ms. McQuaid, Barbara, if you would speak to Sam's point, he's saying that's not going to happen. You just outlined, again, a different case, not a prediction, but a different case where the refusal to testify did result in a lengthy time in jail.
Yeah, I don't want to give Mr. Nunberg legal advice. He certainly should consult with his own lawyer about what he should do in this case. But if his information and his evidence is that Roger Stone did nothing wrong, he should tell that to the grand jury. The grand jury wants to find out the truth. If he's got information truthfully that can exonerate any of these people, that's information that's valuable to the grand jury as well.
Ma'am, how many times should I go to the grand jury? What if they want me again? What if? How many times do I have to go to the grand jury?
If the grand jury wanted you again, it would be because there was some additional information forthcoming during the investigation that they had not had the opportunity to ask you about. So I think this is what's incredibly important here. Sam, you got immunity. So you certainly don't have any reason not to testify, right, as you told us today. Not only that, it actually makes it appear that Roger Stone has something to hide because you will not go testify.
He has nothing to hide.
Well, then go testify.
You know what? I'll tell you what. Okay, so I don't mind about testifying. I'm not going to sit there for 80 hours for this document request. I have real work to do. I have to earn a living. I don't think this is fair. I don't think it's fair to ask me, Paul Manafort, Rick Gates. Once again, like I told you, Corey Lewandowski, Hope Hicks. Do you think I was talking to Corey and Hope Hicks? I mean, while they were having their affair after they screwed over Roger and me? Give me a break. Carter Page? Never met him.
So let me ask you the
Donald, by the way, look at this. Donald J. Trump.
Donald J. Trump is number 3 on the list that you're releasing.
I think that's a problem when they ask that too. Well, now I would turn over anything. But
no, you wouldn't. The whole point, the reason you're here right now, the reason we're talking about all this is you're saying you won't turn over things. That's the problem, Sam. Right?
I'm saying I'm not going to spend 80 hours going over emails with Steve Bannon and Roger Stone because Let me ask you the final... Ari, Roger and me and Steve, we communicated like 50 times a day.
And we talked about that. This is my final question.
Sir.
I appreciate you sharing with us your thinking. It is certainly newsworthy. This is the final question for you. And again, I say this, forget the law, forget the journalism, forget that we're in a TV studio.
Okay.
Is it possible, as someone listens to you and you talk so much about all of these people and you've been through something with them and you feel that you've been through something that's been unfair, is it possible that in the heat of this, you're having a very strong reaction based on the strong feelings you have, and that over time, you might come around to a different view of this? Is it possible that this is coming in the heat of the moment?
I think that in our discussion and what you said, I would have no problem going to the grand jury. But I, once again, don't want to have to spend 80 hours going over email.
You'd rather spend possibly a year in jail than 80 hours going through
I'm not going to jail. You think I'm going to jail?
Sam Nunberg, Maya Wiley, Barbara McQuaid, thank you for
if Mueller wants to send me to jail, that is a joke.
Sam, you've been on the show before. You came on a day when you've certainly made some news, and we appreciate your time. And for those watching, we appreciate you sharing your perspective. What we're going to do is fit in the first break of the show. It's a short break, and when we come back, I have Evelyn Farkas, Katty Kay, and some other analysts. Again, my thanks to all of the panelists.